Welcome to meeting number 15 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of Wednesday, October 28, 2020, the committee is meeting on its study of Bill C-6. This is a hybrid format meeting. We have members Mr. Cooper and Madame Finley, along with myself here in the room, and there are other members joining virtually. I will remind you and the witnesses to please, when you're speaking, when it's your turn to speak, to unmute yourself and to speak slowly and clearly so that interpretation can do its work. You do have the option of picking your language at the bottom of your screen for interpretation. You can pick English, French, or the floor language for your better communication. If you're not speaking, I would ask that you please put your microphone on mute. Mr. Clerk and I will do our best to make sure that this meeting is run in an orderly fashion. Please do address all questions and commentary through the chair, and we'll have a good meeting. Today we are joined by a number of witnesses that I would like to welcome here today. We have appearing as an individual, Colette Ikema. We have an organization, No Conversion Canada, represented by Nicholas Scavio, who's the founder, and Peter, excuse me for this, Gadgets, who's a writer and advocate. Peter, I hope you'll correct me on that when it's your turn to speak. And then we are also represented by the Canadian Association of Social Workers by Joan Davis Whelan, who's the president, and Alexandra Zanis, Social Policy and Communications Coordinator. And then lastly, we will have the Justice Center for Constitutional Freedoms, represented by Lisa Bildy, who is a barrister and solicitor. Each of you will have 5 minutes to speak, and we'll start with Colette Ikema for 5 minutes. Go ahead.
Thank you so much, members of Parliament, for inviting me to present to you today. My name is Colette, and I'm from Lethbridge, Alberta. I am a mom and a wife, and I have 3 of the world's most beautiful children. I'm here today to tell you about how counseling helped me survive terrible trauma. Despite the government's assurances, my life-saving counseling would become illegal if Bill C-6 is passed. And that's why I think it's so important for you to hear my story. When I was a child, I was abused. Because of it, I struggled for many years with sexual behavior and attractions that I did not want. I compulsively masturbated, I had intrusive gay fantasies and rape fantasies. And my developing attractions and behaviors got worse after I was gang raped as a teenager. 3 men that I knew raped me and damaged my sexual well-being. And this horrible moment led to even worse sexual problems, like the use of pornography that involved rape and rape fantasies, both heterosexual and non-heterosexual behaviors that severely distressed me. This trauma negatively impacted my sexual intimacy with my husband. I had difficulty with even casual relationships because they triggered an urge to seek out sexually addictive behaviors, both gay and straight. I saw the world through a lens of sexual pain and confusion, and life became unbearable. Thankfully, I found support in 2 places, from a University of Lethbridge counselor whose service I paid for, and a faith-based sex addiction group. Both helped reduce my non-heterosexual behavior, and this support saved my marriage, my sanity, and my life. The government has argued that Bill C-6 will not ban the counseling I received because it exempts the exploration of a person's identity or its development. But I need to make this clear. I was not interested in exploring my non-heterosexual attractions and behaviors or its development, as I knew where they came from. I needed to reduce these behaviors. Both my secular counselor and my faith-based support group are a practice, treatment, or service that help me repress or reduce non-heterosexual attraction or sexual behavior. And under Bill C-6, this life-saving treatment that I freely chose would be criminal. Even if the government says this bill won't ban my counseling experience, groups like No Conversion Canada, who will be speaking after me, have already publicly stated on social media that they intend to use conversion therapy bans to attempt to shut down the kind of counseling that I received and to shut down the groups that support my right to counseling. There are many legitimate reasons why someone may want to reduce their sexual attractions or behavior, whether they be gay or straight, and those reasons are not for the government to decide. In fact, there's no professional body in North America that includes the phrase reducing non-heterosexual behaviors in their definition of conversion therapy. Even the Canadian Association of Social Workers, who will be speaking after me, Define it the same way as the Canadian Association of Psychologists, as a reparative therapy, not just any practice that attempts to change the sexual orientation of bisexual, gay, and lesbian individuals to heterosexual. Their definition does not mention reducing non-heterosexual behavior by consenting patients. Professional counseling organizations recognize it is not the job of the therapist to set the outcome for the patients. And if professional counselors do not set the outcomes of therapy, why does the government? In fact, isn't conversion therapy wrong because it forces an outcome on someone? If Bill C-6 is passed, isn't it then forcing an outcome on me? Isn't Bill C-6 then a form of conversion therapy on victims like me? When Lethbridge passed a similarly worded bylaw, the public was denied a chance to speak to it. And after it passed, I spoke to a city councillor about my story. Only then did he admit they had not considered people like me when passing their bylaw. I am speaking to you now so that you can avoid making the same mistake. Consider the thousands of other women who are raped and need help. Don't they deserve to get the counseling that will help them achieve their goals? I'm now happily married and a mother, and I know those of you who are parents worry about your kids like I do. If they're ever in trouble, I want to make sure they have access to the same life-saving care that I paid for. Make this bill better by adopting the definition of conversion therapy used by actual professional bodies. This will ensure that this government is not forcing outcomes on patients and instead is recognizing the diversity of our lived experiences. Thank you so much for your time, and I'm available for questions.
Thank you very much, Ms. Ikema. We'll now go on to No Conversion Canada, represented by Nicholas Scavio and Peter, I'll give it another shot, Gadzits.
Thank you. Good morning, and thank you to the honorable members of the Standing Committee on Justice and Human Rights and all those who have made this appearance possible. My name is Nicholas Schiavo, and I'm the founder of No Conversion Canada. No Conversion Canada is a nonprofit, nonpartisan, grassroots, and volunteer-led coalition of conversion therapy survivors, LGBTQ2 individuals, and civil society, experts, academics, and Canadians from coast to coast. We work to eradicate conversion therapy abuse, amplify the voices of survivors, and protect the safety of LGBTQ2 Canadians. Since 2018, we have worked with stakeholders and policymakers across Canada to develop bylaws and legislation to end this torture. I am here today to support this human rights legislation and to provide insight and facts to strengthen Bill C-6 for the safety of all Canadians. I am honored to be here with a pioneer in this movement, a survivor, author, and advocate, Mr. Peter Gajdich, whom I will now cede the rest of my time to.
Thank you. My name is Peter Gajdich. Thank you, Madam Chair. I'm here to make recommendations for Bill C-6 based on my lived experience. I went through 6 years of conversion therapy with a licensed psychiatrist when I was a legal adult between 1989 and 1995. I was 24 years old when I met this doctor, 31 when it ended. I'm the author of the book, The Inheritance of Shame, a memoir about my years in this therapy and my road to recovery. For the past 23 years, I have spoken out about conversion therapy. In 2018, I helped initiate the first Canadian municipal ban on conversion therapy in Vancouver, my home city. I had already come out as gay before I met this psychiatrist. After starting counseling with him, he told me that my history of childhood sexual abuse had created a false homosexual identity. And so my therapy's goal would be to heal old trauma in order to, as he said, correct the error of my sexual orientation and revert to my innate heterosexuality. His methods then included prolonged sessions of primal scream therapy, multiple psychiatric medications to suppress my homosexual desires, injections of ketamine hydrochloride, followed by reparenting sessions to heal my broken masculinity, and when none of his methods worked, aversion therapy. At their highest dosages, he was prescribing near fatal levels of these medications, and I overdosed. I still consider it a miracle I didn't die. I left these 6 years shell-shocked. It was not so much that I wanted to kill myself as I thought I was already dead. I later sued the doctor for medical malpractice. He denied treating me in order to change my sexual orientation. He claimed I had consented to his treatment. He said he had treated me or depression. I imagine some will view my experiences as extreme, that it couldn't happen again today, except these are the exact words I've heard for over 20 years. As I write in my book, the horror of it all provokes disbelief. Though the facts of my treatment will differ from others, I believe the basic principles of a fraudulent practice, combined with a client's vulnerability, trust, and lack of informed consent, will always apply to all, even today. Currently, there are no federal laws that would prohibit what happened to me today with another legal adult, or even that could hold a similar practitioner accountable for their actions. These are my recommendations for Bill C6. The ban must be for all ages. Banning conversion therapy is about ending a fraudulent practice that causes harm. This applies to all. The ban should not include the word will or any suggestion of coercion. Suggesting coercion or the idea of forced conversion therapy, or even mentioning the will of the client, makes it sound as if conversion therapy could be anything other than coercive. It deflects attention away from the fraudulence and harm of these practices and to the actions of the client, their supposed willingness or consent to participate. All forms of conversion therapy are inherently coercive and exist solely as a form of oppression over LGBT people. To imply otherwise is to invalidate the experience of survivors. Proper informed consent is not possible in these circumstances because all of these treatments are based on the false premise, the lie, that a person is broken by virtue of being gay or trans and that they can and ought to be changed. To suggest that a person could consent to such a thing is to say that they choose to do to themselves what has been done to them from the start. It is illogical and defeats the purpose of this bill. Please ban conversion therapy for all, including adults. Thank you.
Thank you very much, Mr. Schiavo and Mr. Gaidich. We'll now move on to the Canadian Association of Social Workers, Joan Davis-Whelan and Alexandra Zanis. Go ahead, you have 5 minutes.
Thank you. Good morning. My name is Joan Davis-Whelan, and I'm the president of the Canadian Association of Social Workers. We represent over 20,000 social workers across Canada. It is my privilege and honor to be here today to provide witness to this historic legislation that will serve to protect all children and youth from those unaccepting of their inherent dignity and worth. The Canadian Association of Social Workers enthusiastically applauds and provides unwavering support to all parliamentarians for their support of BC6. And we call for the Parliament and Senate of Canada to put the safety and security of children and youth first by unanimously supporting and expediting this legislation into law. Any further delay in passing this reintroduced legislation is unacceptable. Not one more child or youth in Canada should endure the harm of this damaging and discredited attack against their persons. I would now like to take a moment to thank the individuals who bravely stepped forward to share their stories of lived experience in enduring the harm inflicted by conversion therapy. Due to your relentless advocacy and commitment to protecting others, the vision of a Canada without legal conversion therapy will soon be realized. In 2018, CASW released a position statement in partnership with the Canadian Psychological Association, strongly condemning all forms of conversion therapy. Conversion or reparative therapy can take many forms, but can be broadly defined as any therapy with the goal of changing or converting an individual's sexual orientation or gender identity, regardless of age. It is important to note that this so-called therapy is not evidence-based, is completely discredited, and causes extraordinary harm, especially amongst Canada's children and youth. We now definitively know and have heard time and time again that conversion therapy directly contributes to two-spirited LGBTQ+ youth experiencing disproportionate and alarming rates of mental health problems, homelessness, poverty, violence, and substance use resulting from this practice. CASW would like to thank the Minister of Justice and the Attorney General of Canada, as well as the Minister of Diversity, Inclusion and Youth, for including the voice of the social work profession during the process of developing this bill. Notwithstanding our steadfast support of this bill, CASW encourages this committee to adopt the key recommendations of the Guide for Legislative Action for Conversion Therapy in Canada. CASW endorses the revised guide. Its recommendations are needed to strengthen this legislation to protect all people from this discredited form of fraudulent therapy. I will now pass over to my colleague, Alexandra Zanis, to provide CASW's recommendations.
Thank you to this committee for asking us to come here today. As listed in our written submission, CASW strongly urges the following amendments to strengthen Bill C6. First, CASW recommends that the bill be amended to include gender expression. Second, any language focused on the issue of consent or coercion is misdirected, as this wording could create a significant loophole limiting the protective effect of this proposed law by claiming an individual can consent to a therapy that has been deemed psychologically harmful. Third, the bill in its current state implies that conversion therapy may be dangerous and harmful to minors, but not necessarily to adults. It is harmful to all people. Fourth, any federal legislation should also revoke the charitable status, if held, of any organization that promotes, advertises, or practices any form of conversion therapy. Fifth, CSW strongly supports investing in a survivors fund to access reparations and supports for those who have experienced this practice. And finally, CSW advocates that funding accompany this bill for education and awareness campaigns, highlighting the need to officially end all conversion therapy practices in Canada. Thank you. I look forward to your questions.
Thank you very much for that. We'll now go on to the Justice Center for Constitutional Freedoms, represented by Lisa Bildy. Go ahead, ma'am. You have 5 minutes.
Thank you. I'm a lawyer with the Justice Center for Constitutional Freedoms. Objectively harmful, coercive practices that are designed to change a person's sexual orientation, as we've just heard about, should be banned. That is what Canadians think of when they hear the phrase conversion therapy. But when it comes to gender identity, improperly conflated with sexual orientation in this bill, what we think we are talking about and what activists mean and are pushing for are not the same. By conversion, they mean talk therapy or watchful waiting to help a child or adolescent become comfortable in their own body, or that addresses other mental health concerns or past traumas, something that about 85% of them will do if given that space. That is what they want banned on pain of criminal sanction. When they say affirmation, they mean rejecting the body a child was born in and embarking on a path of puberty blockers, cross-sex hormones, multiple surgeries, and a lifetime of medication and dire consequences such as sterility and loss of sexual function. There's a whole industry developing around this conversion of kids, and it is being encouraged through the influence of gender activists on social media and even in our schools. Yes, that is the real conversion here that is endorsed and supported by this bill. The LGB Canada report, which I implore you to read, speaks of lesbians and gays saying to each other in whispered conversations, "Thank God I am not a gay kid growing up right now. If I had been, there's no question that I would have identified as transgender and been sent for sexual reassignment." Yet we have to pretend that talk therapy and a cautious, measured approach is the danger. A free society that supports individual rights, as Canada is supposed to be, would allow parents, children, and health professionals to find the best path for each unique child, not have the state preordain that transition is the only permissible option. It is not for the government to dictate such outcomes, and doing so in our submission contravenes the rights of parents and children guaranteed under Section 7 of the Charter. The bill needs to remove gender identity entirely. Other countries are beginning to realize the horrors that have unfolded from allowing and encouraging kids to self-diagnose at the behest of gender ideologues. Progressive Sweden has shifted course dramatically just in the last few months. And in the United Kingdom, we are seeing positive signs of this. The Kira Bell case last week was groundbreaking. It confirmed what many parents, therapists, and other medical professionals have been warning about for years. The affirmation bandwagon puts kids on an irreversible path to permanent changes, which will adversely impact their physical health, bone density, and other complications, and likely cause them sterility and an inability to experience sexual pleasure. The court reviewed the evidence with some horror and concluded that once children go on puberty blockers, they almost invariably proceed through all the stages of transition, and that children under 16 and those likely under 18 cannot possibly provide informed consent to those consequences. Canada's going in the wrong direction. We're being steamrolled by an aggressive ideology that changes our language, undermines our usual safeguards relating to children, demonizes as bigots those who are cautious, refuses to consider evidence which counters the approved narrative, and demands complete fealty on pain of social cancellation. Standing up to this is not transphobic. It is being child-centric and rational, and it is necessary. And it in no way prevents adults who wish to transition from doing so, or even children whose parents and a licensed health professional think transition is the best outcome for that child. But it isn't the right outcome for all children. I was surprised to learn yesterday that the committee would not be hearing from important voices like LGB Canada and DTrans Canada. Detransitioners are ignored because they shatter the narrative. The preamble to the bill says that it's a myth that people can change their gender. But those who have detransitioned are proof that either their gender can be changed or that what some young people go through when they say they are transgender is indeed a phase that they might simply outgrow. Detransitioners are usually homosexual, mostly young people who have gone through medical transition and have some serious regrets. Many self-diagnosed as having gender dysphoria as minors and subsequently accessed irreversible hormone blockers, cross-sex hormones, and double mastectomy without any form of psychological assessment, all by the age of 16. I invited a member of DTrans Canada to share my time today, but that was not allowed. They have three major concerns with the bill as written, which I share. That affirming every single patient with gender distress or confusion as trans, including medical transition, will definitely result in more detransitioners in the long term. It will be illegal for mental health professionals to support detransitioners because they do not seek affirmation, but wish to reconcile with their sex. Minors who have experienced medical malpractice through unnecessary medical transition will have no recourse for redress because service providers will cite Bill C6, which mandates affirmation as the only legal treatment. I encourage members, as part of their due diligence in considering this bill, to read their excellent submissions and testimonials, as well as those of LGB Canada. It's important to make fully informed decisions and get this right. Thank you.
Thank you very much. We'll now move into our first round of questions, starting with Mr. Moore for 6 minutes. Go ahead, sir.
Well, thank you, Madam Chair. Thank you to all of our witnesses. It's certainly an interesting panel because we have a real diversity of views on what is an important bill. And I think we start from the premise that, conversion therapy in Canada and some of the situations that have been expressed even on this panel is completely unacceptable, and there is goodwill on all sides of this debate about banning harmful practices. I think also from some of the commentary that we've heard in the opening remarks, it illustrates perfectly why we need to get this definition right. I heard one comment that we should remove the charitable status of those practicing conversion therapy. Well, we're dealing with the criminal code here, criminal sanctions, removing charitable status. Those are very serious consequences, which is why as a committee, as the Justice Committee, we have to get this definition of what is conversion therapy. We have to get this definition right. And we see in this definition, it's not a boilerplate that we can take from some other legislation, because the definition the governments provide has not been used anywhere else in government or seemingly by anyone else anywhere. So that raises concerns. We're looking at new language, and we have to make sure that the language is right. So to Lisa Bildy, your submission to the Justice Committee states that the definition of conversion therapy is overbroad and as a result does not adequately prohibit harmful practices. Can you elaborate on that? I mean, one of the things I'm looking at the definition and it says designed to change a person's sexual orientation to heterosexual or gender identity to cisgender, or to repress or reduce non-heterosexual attraction or sexual behavior. If if that definition is problematic, could you explain to the committee how you feel it is so?
Well, it puts people on a one-way path here, and I'm speaking specifically of gender identity because it only allows transition to the opposite gender, essentially. So it specifically prohibits any efforts to return to cisgender or to remain cisgender. So it prohibits a whole range of therapies and approaches and desires of individuals that should be legally allowed and that a health professional might reasonably recommend.
Okay. Again, on one of the talking points, I guess we've heard from the government on this repeatedly, is that this bill would not criminalize non-coercive voluntary counseling, such as between a pastor or a faith-based counselor and a congregant in a church context. And given that the government claims that this legislation will protect these conversations, I'm wondering if you could explain whether you feel this would be true in practice, given the current definition of conversion therapy in the bill. When the minister was here, there's things that he said in his opening remarks when he introduced the bill. There's things that they said on the Justice Department website of what this bill would or wouldn't do. But by the plain reading of the definition, it's not clear that the bill will do exactly what the Justice Minister says. So can you speak to that situation that the minister claims is not captured by this bill, but I remain concerned could be captured by the bill?
Right. Well, the fact that so many people have remained concerned that it might be captured means that it's not clear and it needs to be much more clearly drafted. I was also concerned to hear Minister Lametti say that legitimate conversations would not be caught up in this bill. Well, who is defining what is legitimate and what isn't legitimate? Is that something that is going to be determined by activists? And I think that people will be targeted, whether they when they engage in any of these kinds of conversations. If anyone finds out about it, they will be targeted. That's the world we live in. And if it isn't patently obvious and clear in the bill, then people will face sanctions for that.
Do I have some time, Madam Chair?
You have a minute left, sir.
Okay, and I guess that brings me to another point is, the minister has referenced these words that he claims describe what the bill does. The website describes what the bill purports to do. But, as a lawyer, you and I know that, if someone is being charged under criminal code legislation, a judge is going to look at what's in the legislation, what's in the criminal code, not necessarily what's on some old website from years back. And that's why I feel it's important to get this definition correct. So could you maybe point out to the committee how your views on getting the definition right versus things that the minister may say or things that the department may post on their website?
Right. Well,
I'm so sorry that actually brought you up to your 6 minutes, Mr. Moore. Maybe in the next round we can get more into it. We'll now move on to Mr. Virani for 6 minutes. Go ahead, sir.
Thank you very much, and thank you to all of the witnesses, particularly Ms. Akema and Mr. Gadget, for sharing your personal stories. I know that that's difficult and it takes courage, so thank you for being here. I had some questions that relate to, we've heard a lot at this committee with respect to some of the bylaws that exist in other parts of the country. So Mr. Gadich, if you could just comment on two questions off the top, and about, if you could keep your response to about 60, 90 seconds. But have any of the bylaws that have been passed around the country been challenged constitutionally? And what were the results of any of those challenges? Over to you, Mr. Gadich.
Thank you for the question. To my knowledge, none of the municipal bans have been challenged. So that's a quick answer in that regard. But one thing I can add regarding this is about something that happened in the Vancouver ban when it was passed. I helped draft that bylaw. The city of Vancouver decided to write it for minors because of their fear that it could be challenged in court. I spoke at that chamber hearing, and I was so delighted when one of the city councilors spoke up and said, we need to make an amendment to this bylaw and make it for adults, for all people, regardless, because virtually every health organization globally has denounced these treatments as unethical, as fraudulent, as harmful. And if anyone were to challenge this bylaw in court, we would have the world stage at our defense. And so the entire city council unanimously passed that amendment, and Vancouver was the bylaw was for adults, for all.
Okay, so
and to my knowledge, no challenges.
Okay, so I'm just conscious of the time. So with respect to the bylaws that exist around the country, Mr. Gadich, could you just comment on, would you say the majority or all of them now apply this across the board regardless of age, or do some still segregate out minors versus adults?
Nick, I might call on Nick because he runs the No Conversion Canada, and there's a website which actually shows every ban in Canada, whether it's for minors or adults. Nick, maybe you can answer this part.
Yeah, thank you, Peter. And thank you for that question. So, just to reiterate, there are currently 7 provinces and territories with some form of conversion therapy legislation, and currently 14 municipalities across Canada that have some form of bylaw, policy, or declaration regarding conversion therapy. They are each unique. So some of these are, policies to regulate business licenses. But to your question, I think, the gold standard in terms of municipal bylaws would be that of Calgary, which does apply to all ages. And I think as we've seen more municipal bylaws happen, that tends to be the standard. I also just wanted to comment that, to my knowledge as well, there's been no constitutional challenge to any of these bylaws, and that we have seen no statistics or evidence to speak to this boogeyman chill effect in terms of impacting healthcare providers. This is a red herring argument that we've heard time and time again, and I just wanted to reiterate that conversion therapy bylaws and legislation have existed in Canada for many years, and there's been no impact to credible scientific healthcare providers.
Okay, now I want to involve Ms. Whelan and perhaps Ms. Zanis. With respect to your work with the Association for Social Work. We've heard this discussed a bit before, and I personally have some reticence about enumerating a list. So people have said, well, let's make it clear that it doesn't apply to a conversation between a parent or a teacher or a pastor. And the second you enumerate a list, I think you might be faulted for not including a coach or a music instructor or some sort of mentor or a Boy Scout leader. You have your pick. What are your views on the definition as it's entrenched right now in the legislation versus zooming out and creating a list of the types of conversations that are not meant to be caught? So Ms. Whelan.
I'm actually going to defer to Alexandra Zanis on this question.
Thanks, Joan. Yes, thank you for the question. That is an excellent question. We do not believe that it should be amended to include a list. To be very clear, this legislation isn't necessarily with the goal of targeting healthcare professionals such as social workers. Social workers and other healthcare professionals adhere to very strict codes of ethics and guidelines and regulatory bodies, of which all of these practices, including talk therapy or the gentlest forms that we have been discussing here, would already be a deep violation, and they would already face deep code of ethics violations there. So the point of this legislation is really to get at those unregulated individuals, like you said, who have the goal to change, alter, or deny an individual's identity. So I think that we think that leaving it the way that it is would be the most beneficial in this scenario. Once you start to get into the list, exactly like you're saying, we're starting to create loopholes. And what we need is a federal ban on this practice to get at those unregulated individuals that adhere to no regulatory body when providing practices under the guise of therapy.
Thank you, Ms. Zanis. I'm just conscious of my time. Thank you, Ms. Zanis. Ms. Bildy, I presume we're not going to agree on certain things, but can we agree that you mentioned the best interest of the child, that it is not in the best interest of a child to be forced into a therapy to which they are being coerced or taken against their will? Do we agree on that point?
Well, yes, except for the fact that what we're hearing from the court in the UK last week is that children are not competent to give informed consent to what follows after a course of puberty blockers. So you have to bear that in mind. Children should not be forced, to. I certainly believe, with respect to children's sexual orientation, that they should not be forced to undergo anything that makes them try to change that. I agree with you completely on that. But gender identity is a totally different kettle of fish. It's being strung along here in a bill that really should focus on sexual orientation only.
Thank you. Thanks very much. I will now move on to Monsieur Fortin. Sir, you have 6 minutes. Go ahead.
Thank you, Madam Chair, and thank you to our witnesses for being here. This is a topic that is fairly controversial, conversion therapy, and the more witnesses I hear, the less I know what we should really do with this bill, because we're walking on eggshells here. I would first ask a question of Ms. Akima. Could she tell us a little bit about her counseling and support that helped her? Does she agree with me that pastors or religious groups are very influential, and they can certainly have an effect on young people who might then end up in conversion therapy?
So much for the question, Monsieur Fortin. I absolutely agree with you that it's very possible that it's very possible that let me rephrase that. Could you rephrase the question one more time?
La question était de savoir.
My question is really, when we talk about conversion therapy, and from what you said, that can happen with religious leaders. So regardless of the religion concerned, do pastors and religious leaders not have too much influence and therefore might change the mind of a child that is exploring his or her identity or sexual orientation?
Regardless of the influence that faith leaders have, every person influences other people with their speech. Even you are influencing me right now with the things that you are saying. And so absolutely, I would argue that the help and support that I got from the faith-based support group that I attended to deal with my sex addiction issues, the impact that they have was absolutely monumental in saving my life and helping me heal from trauma. So the impact that is there is absolutely true. And we need to make sure that the impact of this law is not going to be to restrict faith-based organizations and faith-based ministries and support groups and counselors who are trying to help individuals like myself to meet our goals and our outcomes, because conversion therapy is wrong because it forces an outcome on someone. And so I agree with you. We should never force an outcome on someone. And if that's what a pastor is doing, then they can be held, they already should be held responsible for that. The issue is that what we're talking about is that we're trying to mandate the outcome. The government is trying to mandate the outcome of counseling, and the mandate is trying to mandate the outcome of what a faith-based group should or should not be doing, which is a direct infringement on religious freedoms.
Merci, Madame Akima. J'aurais une autre question pour Maître Bildy.
I have another question. My question is for Ms. Bildy. If I understood correctly, you are concerned about the definition in Clause 5, that is in the Criminal Code 320-101. So I would like to know how you understand that definition. What would be allowed, what would not be allowed under the current wording of the bill?
What you're referring to. Bear with me for a moment.
En fait, je parle de
I'm talking about the definition of conversion therapy, which would be at 320-101, and it's Clause 5 of the bill.
Right. Well, my concern is that exploration of, gender identity should be removed entirely. I mean, that, it's interesting when you hear the people saying now that we should ensure that gender expression is subject to this bill as well. Well, there's a lot of convoluted inconsistencies in all of this. I mean, when you think about it, gender expression allows children, for example, to express themselves outside of what we would consider stereotypical gendered behavior. But typically now we find that when kids do act as though, they perhaps a very tomboyish female or a very effeminate male, they often now, despite the fact we should be embracing their expansion of gender categories, they're getting put on a transition bandwagon and suggested to them that, that perhaps they're in the wrong body. So even what people are asking here to include both gender expression and gender identity are mutually exclusive. And so you really need to go back to the drawing board on this. And I think the easiest thing to do is to get rid of gender identity entirely. It just doesn't belong here.
Okay. Mais vous êtes d'accord?
But you agree, if I understand correctly, with the proposal that conversion therapy should be banned. So if there was a professional that wanted to change a young person's identity or influence that child in either direction, that is, by saying to the young person, you are in the wrong body, or you have the wrong orientation. So given that these are minors, that should not be allowed. Is that correct?
Bill,
my apologies, but Monsieur Fortin,
that you cannot
sorry,
change a person's
Ms.
gender
Bildy?
identities to cisgender.
Ms. Bildy?
It protects transition.
Sorry, Monsieur Fortin is out of
Madame
time.
la Présidente, j'ai pas compris la réponse.
I didn't understand the answer because you were speaking at the same time.
The time is up, Monsieur Fortin, and I was just alerting you to the
Madame la
fact.
Présidente,
But, Madam Chair, I would just ask you to be fair, because the interpretation probably takes some time, and so we should just give the witness 5 or 10 seconds to give an answer, because the interpretation has to take a few seconds after that. So I just wanted to make that point.
For a very, very short response, please.
Sorry, I can't hear you.
Ms. Bildy?
Did I have authorization to go? Thank you.
Yes, go ahead. Very, very briefly, please.
Okay, yes, the bill, though, only allows the transition in one direction. You see, it's when you say that people could be influenced either way, well, only one is banned under this legislation. Only one way to change a person's gender identity to cisgender is banned. Okay, so if somebody is trying to change them in another direction, that's okay. And in fact, it's specifically allowed as a treatment or service that relates to a person's gender transition. So it's a one-way street.
Thank you. That's all the time we have for Mr. Fortin. We'll now go on to Mr. Garrison for 6 minutes. Go ahead, sir.
Thank you very much, Madam Chair. I want to start by thanking the witnesses for being here today, and in particular, Ms. Aikema and Mr. Gajic. To tell your personal stories in public is quite difficult, and I thank you for having the courage to do so. I also want to say, as the author of the bill which originally provided protection against discrimination on the basis of gender identity and gender expression, I'm always disappointed when transphobic arguments are brought before the committee in public, even if they're dressed up in legal language, and especially when they're connected to a false narrative about detransitioning and a false concern, stated as a false concern for children. So on the basis of that, I'd like to ask the Canadian Association of Social Workers why they believe it's important for both gender identity and gender expression to be included in the ban in this bill.
Yes, thank you for that excellent question as well. As it stands right now, we are seeing that the loopholes in the legislation will allow for these practices to continue, and that by not including gender expression, we will continue to see these harmful practices that lead to overrepresentation in homelessness, mental health crises, substance use, poverty, and addiction. So if we want to get this right for the things that we know are already happening, not the things that we think may happen if this legislation gets introduced, we need to include gender expression, and we need to include trans people within this bill through gender expression specifically. If we continue to leave out gender expression, we will continue to see these practices, which will continue to lead to the overrepresentation of 2S LGBTQ2+ people within the social workers' offices.
Great, thanks very much. This bill leaves the concept of consenting adults as able to submit to conversion therapy. So I'd like to ask No Conversion Canada. I know they mentioned this in their original presentation, and of course I personally support a full ban. But on this question of consenting adults, do you believe that adults can in fact consent to something that is fraudulent and harmful?
No, we do not. So thank you for that question very much. I think it's important to note that all conversion therapy is inherently fraudulent, coercive, and dangerous. So the government legislation should apply to all ages without exception. The notion that only forced conversion therapy is prohibited, and by contrast, there can be such a thing as consenting adults, is misguided. There's no such thing as good conversion therapy. There's no such thing as honest conversion therapy, because it is based on a false premise that LGBTQ2 identities are somehow invalid, wrong, abnormal, or undesirable. This is a false premise. I also want to note that conversion therapy has been confirmed as a form of torture by the International Council on the Rehabilitation of Torture Victims. And it's important to note that they explicitly reference both sexual orientation and gender identity and all forms of conversion therapy in their study. You cannot consent to torture. You cannot consent to harm. And we should not be making hierarchies of torture where we condemn lobotomies but condone psychological abuse, or where we condemn conversion therapy for youth and condone it on adults. It is all harmful, and it leaves its victims with lifelong trauma. And just to use a very quick example, it's the same reason why I cannot create my own vaccine for COVID-19 and go out on the street and sell it to the top buyer. Obviously, there are people who are struggling, they are scared, but to do so would be committing harm on a false premise of consent that would be inherently fraudulent. And so that is kind of the example I would use for conversion therapy as well. It needs to apply to all ages.
Thanks very much. I want to return to the Canadian Association of Social Workers on this question of consent and see if they have anything further they'd like to add.
Yes, exactly. I would completely, wholeheartedly echo No Conversion Canada. You cannot consent to a practice that at its core has been deemed fraudulent, baseless, and harmful. The idea that an individual could consent to a practice that at its core is trying to change, alter, or deny who they are, who they want to be, is again going to create those loopholes that we're trying to get rid of with a federal ban. So yes, consent should absolutely be discluded, and we echo everything that No Conversion Canada has to say in regards to that.
And do you, as the Canadian Association of Social Workers, see anything in this bill that would in any way inhibit you in dealing with your clients and making sure they get the supports and services they need?
Absolutely not. No, conversion therapy in all of its forms, in every single form that we have talked about here today, is a deep violation of a social worker's code of ethics. They will not be able to practice and be a registered healthcare professional or a registered social worker outside of this bill. This bill is for us to say who is doing these practices and how do we ensure that they are regulated like all other healthcare professionals that have to adhere to strict guidelines and codes of ethics, one of which to respect the inherent dignity and worth of all persons. Conversion therapy does not do that. So for social workers, we are already in the realm of you cannot practice if you are doing any form of conversion therapy. So therefore, no. If you are someone who is looking for gender affirming or any kind of social services around LGBTQ2+ gender expression or sexual orientation, you will absolutely be able to see a social worker and have any of the conversations you need, with the goal not to be to change, alter, or deny who you fundamentally are.
Thank you very much. Madam Chair, am I close to being out of my time? I'm afraid that
10 seconds, yes, Mr. Garrison.
Okay, thank you very much to the witnesses.
Thank you. We'll now go to our second round for 5 minutes, starting with Mr. Cooper. Go ahead, sir.
Thank you very much, Madam Chair, and thank you to all of the witnesses, including those who have told their stories and experiences. I know It is not easy. I will address my first question to Ms. Bildy. Perhaps you wish to pick up on where Mr. Moore left off, namely how assurances on, for example, the Department of Justice website would hold up in court relative to what is actually in the law.
Well, I think, excuse me, I think you're going to hear another witness in the next hour who is a criminal lawyer and can speak to that very specifically. But certainly in my experience, the letter of the law that is, part of the criminal code and on the charge that someone is going to be issued is what you would be looking at primarily. Most lawyers are not going to go digging around on old websites trying to find some exception. It might become relevant to a degree, but I think that any exceptions and clarity needs to be put directly into the bill for maximum protection.
Thank you for that. You cited the recent UK High Court decision a couple of times. I just wonder if you could be clear in terms of the connection or relevancy between the findings in that decision and the subject matter of this bill.
Right. Well, what you're basically endorsing with this bill is for kids to self-diagnose their own gender identity at a very young age, potentially as young as 3 or 5 years old, and to have that confirmed and supported and pushed through without any question. Okay, you're talking about 10 or 12-year-old kids going on puberty blockers at their will and wish, without anybody being able to say, maybe this is a bad idea. Maybe the fact that 10 or 12 kids in your class have all decided that they're trans might be influencing you here. Maybe this isn't something that is in your best interest. We're not allowed to say that. We have to accept the child's self-diagnosis of their gender identity and then allow them, if they want, and they're all taught now on the internet how to push for puberty blockers and make the arguments to allow them to get those, that they will be then on this path, which they will not be able to get off. 99% of those kids, once they start on puberty blockers, will go the distance. Many of them will, it's the wrong decision for them, and they will regret it later. This is happening in Europe, and we are not far behind. In the UK, the decision dealt with a young woman who had transitioned fully, had a mastectomy and so on, and came to regret it. And she challenged the fact that she was not given any proper therapy or diagnosis of other underlying conditions from which she suffered. And she was basically pushed through because of dogma like Member Garrison is talking about, that it's transphobic to suggest that you should care about children and their well-being. That is just wrong, and you are going to pay a price for that one day.
Madam Speaker, on a point of order, I firmly
yes,
believe
Mr. Virani?
I firmly believe that we can disagree.
Yeah.
And I'm not purporting to take away time from Mr. Cooper. I just firmly believe that we can disagree without being disagreeable, and comments like that are not appropriate when they're volleyed at any member of Parliament, including the members of this committee. So,
point of order.
I could just ask the chair to perhaps caution the witnesses in their uses of terminology. Thank you.
Thank you, Mr. Virani. Madam Findlay, you have a point of order?
Yes, we have heard testimony in this committee, both in the last bill and this one, where witnesses attacked, that's the word, attacked other witnesses and attacked members of Parliament without comment from my colleague, Mr. Virani, if it was in line with his thinking on these bills. You cannot say to one witness, you cannot take issue with other testimony and not do it for each and every one. That is totally improper.
Thank you, Madam Findlay. Mr. Moore, did you also have a point of order?
Well, in a similar vein to Madam Findlay, the time for Mr. Virani's intervention would have been when Mr. Garrison started throwing out offensive terms and disparaging our witnesses. Witnesses are here. Many of them, it's probably their first time being before a parliamentary committee. This is their time. Let's listen to them. But I think it's a two-way street, and respect has to come from our members of Parliament towards the witnesses as well. We shouldn't disparage any of them. I think every witness here today has brought something of value, and that's what we're discussing. So let's try not to whether it's witness to witness or parliamentarian to parliamentarian or between parliamentarians and witnesses, let's just have a respectful dialogue. Thank you, Madam Chair.
Thank you, Mr. Moore, and I thank members for raising the points of order. I will remind members that witnesses do have privilege when they come before committee to testify. And with that privilege, we hope that we can have respectful dialogue, respectful debate on the issues that are before us. And I encourage all witnesses and members to please be mindful and be respectful to one another as we endeavor on this study. Thank you for raising this. Mr. Cooper, back to you.
You, Madam Chair. Ms. Bildy and Ms. Akema, both of you in your testimony referenced that the bill forces outcomes or dictates outcomes. Can both of you just elaborate on what you mean by that?
I would love to elaborate on that because I think the real point of order needs to be the fact that Mr. Garrison just said that I don't exist. That should be the real point of order, because how dare anyone dictate what my counseling experience was? We need to understand that just as it is very traumatic to deal with rape, it is very traumatic to hear people talk about the fact that they want to take away my life-saving therapy, because you are saying that all forms of conversion therapy are coercive. I have just explained to you that the trauma I went through was coercive, but that the counseling that I chose to meet my goals and the outcome that I needed to heal from my trauma was not coercive. I wanted this therapy and I had a right to it. So who are these people telling me what I should want as a survivor of rape? The counseling I went through was not coercive nor torture. It was the trauma of this bill and what's happened before that's making this much more difficult.
15 seconds.
Ms. Bildy?
Right, and can I just clarify and follow up on my last comment with respect to the UK decision? What was important about that decision, and the members do need to know, is that children were found in that decision, to anyone under the age of 16 for sure, and possibly under 18, they do not have the capacity to consent to the kind of one-way treatment that this bill will require. They don't have the capacity. And so we are, I'm honestly, I'm trying to help you not to face the music down the line when we have a whole slew of people coming through. I mean, the number of particularly young girls that are going through gender transition now in some countries, I'm not sure Canada's number offhand, but I just saw Sweden's was a 1,500% increase in young girls over a 10-year period. There's something going on. You need to make an evidence-based decision, but not all these girls are transgender.
My sincerest apologies, but Mr. Cooper is out of time and we're about a minute over his time. We'll go now to Mr. Zuberi for 5 minutes. Go ahead, sir.
I want to thank all the witnesses for being here, and also to underscore what my colleague Mr. Brani just said, which was that, you know, we all are coming from different perspectives and we all have strong opinions on this, and that's normal. What I think our duty here is to listen to each other, to do so in good faith, and to consider fully the testimony that we are hearing at this moment. So I just want to put that out there, that I personally and also want to applaud both Ms. Akema and Mr. Gaidich for sharing your stories. I know that it's very challenging to do so. This is a very condensed moment where we have few minutes, but this is important. What you're saying is important to us, and we're listening. I wanted to put out to the Canadian Association of Social Workers, in particular Ms. Davis Wheelhan, the question around peer review subject matter, peer review studies on the impacts of conversion therapy. And you did go into this a bit in your first 5 minutes. Can you elaborate upon that now briefly?
Yes, I think actually that might have been Alexandra who did so in the first few minutes of the conversation. But in terms of peer reviewed, it means basically that what you're referring to is the fact that we have people who are experts in the area who are recognized and credited for their knowledge and experience to review materials, studies, etc., and then make determinations as to whether or not the material is appropriate, etc. To our knowledge, there is nothing that has substantiated that for conversion therapy. It has been discredited.
Okay. So just to reiterate, you're saying that it has been discredited, that there have been no positive outcomes, and that there have been all negative outcomes with respect to what studies have said with respect to conversion therapy.
If we look at this from the point of view of do no harm, right, then there's nothing in there in terms of conversion therapy when we talk about it in terms of a positive response. It has been harmful.
However, in terms of the legislation as it's drafted right now, it allows for essentially what is a good faith conversation between a professional and somebody who is seeking to explore their identity, to enter into a conversation that is directed, directed from your client, so to speak, and allows them to, for example, if they want to reduce their sexual desire or other type questions in this legislation, they can enter that conversation with you and you can help them achieve whatever goal they want to achieve. Is that correct?
Yes, and I think, Alexandra, is there anything else you'd like to add to that?
Sorry, I think I was muted. No,
if you don't have something else to add, I had another question with respect to analogous type categories of individuals, including faith leaders or mentors, a teacher, a parent, a family member. You said that you yourself can enter into those conversations that are person-directed, directed from your client. If that same person turns to their faith leader, to their coach, to their teacher, to their sibling, to have an open conversation, with feedback, honest feedback, they can still do that type of exploration. Do you understand it as such, the legislation?
Yes. Yes.
I don't know if I hope this I won't go into any more. This is really what I wanted to really flesh out. I think that I want to underscore what Mr. Vrani said before, and I think we all agree to that this is very important. To what Mr. Fortin said also, this is a delicate matter. We do want to listen to everybody and hear your truths. And I do actually want to again applaud Ms. Akima and Mr. Gaidich for being with us. Thank you.
Thank you very much, Mr. Zuberi. We'll go now to Monsieur Fortin for 2.5. Sir.
Merci, Madame la Présidente.
Thank you, Madam Chair. I would like to go back to Ms. Bildy in the definition of conversion therapy, because this is really the critical point here. We need to know what will be banned and what won't if this bill is passed. So it seems to me that it says that practices, treatments, and services for the exploration and that exclusion won't be problematic. So what do you understand by it?
Well, I understand that it's not clear, and I know that a lot of people find it unclear, and it will provide, even if the therapists think that perhaps it might leave an opening, they're going to still feel the chill effect of knowing that this is in criminal legislation. Here's the criminal code, and so it will prevent people from engaging in anything other than affirmative only transition when it comes to gender identity and particularly with children. The people that you needed to really hear from to sort this out were specialists, and we have many of them actually in Canada who are experts in this field, like Dr. Zucker, Dr. Cantor, Deborah So, they were.
I'm sorry, I don't want to be rude, but as you know, there is very little time for each of us to speak. So you said earlier that it is dangerous to have young people transition too early. As adults, they might regret it and want to detransition. But it says that gender transition will be allowed. But don't you think that it will be possible for a child or teenager to be able to transition even if this legislation is passed? Is that your understanding as well? Ms. Bildy.
Says specifically that any conversion therapy means any practice designed to change a person's gender identity to cisgender. And then it says it does not relate to a person's gender transition. I mean, so those two are these.
Je parlais de l'exception à la fin.
No, I'm talking about the exception at the end of the paragraph. There's an exclusion and an exception at the end.
For a person's gender transition. We don't know what that means. And by the way, that doesn't help kids who we think, should properly take some time to consider whether this is best for them through that watchful waiting approach, which has been a valid form of treatment for many kids and perhaps not exercised enough.
Thank you. Thank you very much. My apologies again, but we have 2.5 minutes left of this panel going to Mr. Garrison. Go ahead, sir.
Thank you very much, Madam Chair. And just let me say to Ms. Aikema that I'm sorry if I left any impression that I believe that her experience should not be affirmed and supported. I don't believe the bill takes away her right to have her experiences, her identity, or anything that flows from that not affirmed. So, I will be proposing some language to amend the bill to make that a bit clearer. I want to go back to No Conversion Canada and talk for a minute about something we've heard from a number of witnesses and briefs presented, and that is that the bill bans advertising of conversion therapy. There's been concern that this would not include unpaid promotion. So No Conversion Canada, I would just wonder whether your position would be that the bill should be a bit broader in the prohibitions around advertising and promotion.
Yes, thank you for that question. I'll keep it brief given the time. Our position is that the ban should cover both paid and unpaid advertising. And I think one of the key recommendations we make in our brief that was submitted to the committee was that the legislation should also cover referrals. We know that these kind of informal referrals and this insidious network is largely how conversion therapy spreads. Typically, conversion therapy goes by different names and it's not necessarily publicly advertised. And so it's important to make sure that those who are referring LGBTQ2 individuals to individuals or organizations that will cause them harm, are also covered by the bill.
Thank you very much for that additional point, which I think is well taken. I want to go back with I guess probably my last question to the Canadian Association of Social Workers and ask about how frequently you believe the practice of conversion therapy in its various forms is in Canada, because we've had some expressions of disbelief from people saying that this surely must not be going on.
Yes, thank you for your question. Unfortunately, these practices are happening and they are happening at an alarming rate because we're not seeing them when they're happening at their inception. We're seeing them when they end up in other social service settings. So those seeking healthcare, housing supports, food security supports. So what we know is that they're happening, unfortunately, at an alarming rate. It is happening, and we're unfortunately catching it too late once the practice has already happened. So we need to be catching it before individuals end up in deep socioeconomic and psychological harm.
Great. Madam Chair, I think I'll conclude my questioning there.
Thank you. Thank you very much, Mr. Garrison, for always being so timely. With that, I'd like to, on behalf of the committee, like to thank all of the witnesses for your testimony today, for taking the time to answer questions, and for sharing your experiences. If there are any additional clarifications that you need to provide to the committee, please don't hesitate to submit anything in writing through the clerk so we can get further clarification on questions that were asked of you today. With that, we'll suspend the meeting as we transition into our second panel. Thank you once again to the witnesses. We're studying Bill C6, and we welcome our guests and witnesses for this second panel. Just before we go into that, I'll remind our witnesses and members that when you are speaking, please speak slowly and clearly with your microphone unmuted, and when you are not speaking, to please have your microphone on mute so as not to disrupt other speakers. And I will remind members and witnesses as we deal with this bill to please maintain respectful dialogue at all times and to be respectful to fellow members and witnesses at all times. It is in our best interest that we get through this and hear from a diversity of opinions. With that, I'd like to introduce our witnesses for the second panel. As an individual, we have Dr. Jane Dobson. We have Daniel Santoro, who is a barrister and solicitor. And we have Rabbi Michael Whitman. We also have, representing the Archdiocese of Toronto, His Eminence Cardinal Thomas Collins. Welcome. We'll start now for 5 minutes with Dr. Jane Dobson. Go ahead.
Thank you, members of Parliament, for this chance to speak with you. I am here as a concerned family physician. I want you to picture a young teenage girl who starts to question her gender identity. As you may know, questioning and exploring identity is a key part of adolescent development. She is referred to a gender clinic by her family doctor. Instead of having her anxiety and depressive symptoms treated, she is fast-tracked onto puberty blockers and cross-sex hormones, and at age 20, she has both breasts removed. At age 23, she regrets her hasty decision and begins to detransition. She is left with a permanent 5 o'clock shadow, a permanent low voice, and no breasts. Now she wonders how all this happened to her simply because she questioned her gender identity. She says, "I made a brash decision as a teenager, as lots of teenagers do, trying to find confidence and happiness, except now the rest of my life will be negatively affected. I feel like I was a guinea pig." This is not an imaginary person. This is Kira Bell, the young woman who successfully sued England's Tavistock Gender Clinic. As a result, the British High Court has now ruled that children must understand the immediate and long-term consequences of taking puberty blockers to be able to consent. The court's permission is now needed to start anyone under 16 on puberty blockers and cross-sex hormones. I wish I could share specific stories from my and my colleagues' medical practices, but of course I cannot. But are adolescents being fast-tracked onto this biomedical regime here in Ontario? Yes. Why are their concomitant psychiatric diagnoses not being treated first? Well, the therapist will be accused of conversion therapy. You see, in Ontario, since Bill 77 was passed in 2015, the psychotherapy first approach has been stigmatized as conversion therapy. But this psychotherapeutic approach has a proven positive track record. Prior to 2015, when a gender-confused child received this treatment, they would be helped and encouraged to identify with their natal gender and be allowed to go through puberty unobstructed. Studies show that 80 to 88% of these children identified with their natal gender by adolescence. They accepted their biological body as their own. Now, however, only one approach is offered, gender affirmation. Only one narrative is spoken, that gender identity is immutable. What happens to young children who receive the gender affirmation approach? They are first socially transitioned, given new names, pronouns, new clothes. Then when they show early signs of puberty, they are placed on puberty blockers, which can cause brittle bones and may arrest natural brain development. Then they're placed on cross-sex hormones, which can increase anger and aggression, acne and hair loss, cause liver dysfunction, increase the risk of heart attacks and strokes, diabetes and blood clots, and cause sterility and sexual dysfunction. If they have further surgeries, they may well experience urinary incontinence. One might well ask, how can a young child, a 5-year-old, legally consent to this? The developmental stage of a 5-year-old is still in concrete thinking. They can have no idea what could have happened if they'd been offered the psychotherapeutic approach. They also can have no ability to understand what the future risks of this biomedical approach will entail. My question is, why is the government telling people what sexual or gender goals they should have? They are effectively doing this with Bill C6, as the bill broadens the definition of conversion therapy from abusive and coercive therapeutic practices to also include talk therapy, watchful waiting, interpersonal conversations, and spiritual practices, widening the net to now potentially criminalize parents, spiritual leaders, and medical professionals for simply practicing tested and tried therapy to help an individual reach their self-directed goals. Further, it shouldn't be the government who decides which theories and therapies win out, but the scientific community itself as it debates, studies, revises theories, and moves forward. What we should be asking is why referrals to gender clinics are soaring by as much as 1,000%, especially in adolescent natal females. Why concomitant psychiatric diagnoses are so high, diagnoses that often predate the gender dysphoria. Why there are a growing number of detransitioners. Instead, Canada is seeking to stifle these questions by criminalizing proven therapy and allowing only one viewpoint to be heard. Sweden is in the midst of a major review of their gender clinics. Finland has gone through their review, and now they require that psychiatric comorbidities be treated before medical transition is considered. Instead of following the examples of England, Sweden, and Finland, we are going in the absolute wrong direction. Will it take a lawsuit to change our direction? How many Kira Bells need to happen here in Canada before we change our approach? Before we truly respect the rights of all Canadians? Thank you.
Thank you very much, Dr. Dobson. We'll now go to Daniel Santoro for 5 minutes. Go ahead, sir.
Good afternoon. I am a lawyer in Toronto, Ontario, with extensive experience conducting complex criminal trials and appeals for all manner of offenses. Thank you for providing me with the opportunity to testify respecting this proposed conversion therapy offense. There are three main problems with this legislation as currently drafted. I'm going to suggest solutions to all these problems, which I think are simple and consistent with a lot of the evidence you've heard. The first problem is that the definition of conversion therapy is overly broad and imprecise, and is likely to capture situations which are not actual conversion therapy and cause confusion. The second problem is that the existing exception for medical treatment is too narrow because it specifies only one lawful form of treatment, gender transition. The third and final problem is that the exception allowing exploration of identity is unclear and does not adequately protect charter freedoms. The first problem, the definition of conversion therapy, is overly broad and imprecise. Multiple provinces have or are considering conversion therapy legislation. In all cases, this legislation is passed pursuant to the provincial power to regulate healthcare. In order for this bill, Bill C6, to be a valid exercise of federal criminal law power, it must have a criminal public purpose, which means some specific public evil that is targeted. In this case, I think everyone can agree that the target is coercive and harmful practices that are designed to change a person's sexual orientation or gender identity. The bill defines conversion therapy as a practice, treatment, or service designed to change a person's sexual orientation to heterosexual, gender identity to cisgender, or repress or reduce non-heterosexual attraction or sexual behavior. There are many difficult to define and undefined terms and words in this definition. There are many difficult concepts which are going to be very difficult for criminal courts to nail down. This is going to prove a very difficult definition to interpret for many, many reasons that you've heard from different witnesses. There are realistic situations which will arise which may be captured by this definition. For example, we've already heard mention of whether a therapist will be allowed to assist an adult person who wants to go through a detransitioning process, or whether a youth who is experiencing gender confusion will be able to access any therapy that would be affirming of their birth gender, and many other situations as well. The difficulty is that if this definition is not properly tailored, it will be seen perhaps to not only be unconstitutional because it regulates criminal in the field of healthcare, but also overbroad and contrary to Section 7 of the Charter. So my first suggestion is very simple. It's that you need to restrict the definition to a coercive practice. So I would suggest the definition should read conversion therapy is a coercive practice. This is a clear definition of a criminal public purpose. Coercive is a well-known term in the criminal code that comes up in other sections. You can also consider whether you want to add the requirement that conversion therapy cause harm, whether that be bodily or psychological harm. Those are also well-defined concepts in the criminal code. The other problem with this definition is mainly in the last part. So if we define it as conversion therapy as a coercive practice designed to change sexual orientation or gender identity, and remove all that extraneous language with relation to specifying sexual orientation to heterosexual, gender identity to cisgender, repress or reduce attraction or behavior, we can be very much more simple in our definition here by just saying conversion therapy is a coercive practice designed to change sexual orientation or gender identity, and remove the rest of the language. The second problem is with the medical treatment exception. It only specifies one sort of medical treatment that's allowed, and that's gender transition. Other medical exceptions in the criminal code, in order to avoid delving into the provincial regulation of healthcare, set out objective criteria according to which a judge or a person can understand whether what they're doing is allowed. They allow, in the euthanasia provisions and other provisions in the criminal code, when medical treatment is discussed, the exception is phrased, any treatment is allowed if exercised with reasonable knowledge, skill, and care. It does not specify one particular form of treatment which is allowed to the exclusion of all other forms of treatment. Not only is that not allowed and unconstitutional because it would be regulating healthcare, it would be arbitrary and overbroad because it captures situations such as treatments that a doctor such as Dr. Dobson or some of her colleagues may suggest that aren't gender transition. So what you need to do is employ objective language. The third issue has to do with the...
Mr. Santoro, you are out of time, but hopefully your recommendations will come out in the questioning. We'll now move on to Rabbi Michael Whitman. Go ahead, sir, for 5 minutes.
Madam Chair, members of the committee, I'm honored to appear before you today to speak in support of Bill C-6. My name is Michael Whitman. I'm the senior rabbi of the Daft congregation in Hampstead, a modern Orthodox Jewish synagogue. I'm a sessional instructor at McGill University Faculty of Law. I'm involved in many communal efforts in Montreal and across Canada, and I've been engaged in providing pastoral counseling throughout my career of 37 years and counting. My involvement in this specific issue began in 2012 when I read that the renowned psychiatrist, Dr. Robert Spitzer, who years earlier had written a seminal paper that was used to support conversion therapy, recanted that research and wrote, "I owe the gay community an apology." After learning about the destructive effects of conversion therapy and hearing firsthand the harm of its effects, I would rephrase the now widespread sentiment against conversion therapy. Paraphrasing the Bible, we are ashamed of what we did to our brothers and sisters. We saw them suffering when they cried out to us, but we did not listen to them. Today, I ask that you do listen and take action to prevent this particular cry from ever being repeated in Canada. For me, this is a straightforward issue of human rights. I find the earliest expression of human rights near the beginning of the Bible, that every human being is created b'tselem Elokim, in the image of God, cherished by God, deserving of respect and dignity. Our rabbis in the Talmud expanded this into the wide-reaching rubric of kavod habrios, the innate right of human dignity, that we are prohibited to embarrass, humiliate, or debase anyone. About 5 years ago, I was appointed the annual convention chair of the RCA, Rabbinical Council of America, the largest professional organization of Orthodox rabbis. And my committee and I had the responsibility to program instruction and resources for rabbis across North America and the world to assist them in leading their congregations. The theme we chose was caring for LGBT individuals and their families. And our goal was to listen to these individuals and the helping professionals who support them. I am proud that the RCA gave prime time to a subject that enables all rabbis to do our jobs better. It's central to my mission as a rabbi and my identity as a Jew to make every human being feel welcome and respected. Conversion therapy does just the opposite. It is inherently belittling and dismissive. It demands people live inauthentically, untrue to themselves, and requires a harsh cure where there is no disease. Its methods are often humiliating and traumatizing. There is no place for it in Canadian society. I remember hearing a radio interview. Dr. Spitzer was asked how he felt after writing his retraction at the age of 80, that his entire life's work and reputation would be tainted by this one research paper. And I remember he said, "I feel very bad, of course, for the hurt I have caused. But at the same time, when I realized I was wrong, I retracted it. I said it was wrong, and I apologized to those I had hurt." Not many people do that, and that is something to be proud of. Conversion therapy has continued in Canada for far too long. It is wrong, and I ask you to do something about it, and that will be something you will be proud of. Thank you very much.
Thank you very much, Rabbi Whitman. Mr. Housefather does send his regards. I believe he's your representative, and he's very happy that you're here today. We'll now go on to His Eminence, Cardinal Thomas Collins, for 5 minutes. Go ahead, sir.
Thank you very much. Good afternoon, and thank you for providing me with the opportunity to speak with you about Bill C-6. I am grateful for the work of the Justice and Human Rights Committee and for all that you do to serve our country in your role as elected members of Parliament. As the Archbishop of Toronto, I serve as the spiritual leader of 2 million Catholics in the Greater Toronto Area. At the outset, I should clearly state that the Catholic Church opposes any coercive practices that undermine a person's free will and human dignity. We believe that every person is a gift from God, to be treated with love, compassion, and respect. In a society where mutual respect and love of neighbor should define us in all that we do, we must all ensure that no one experiences coercion or manipulation. I'm most appreciative of Minister Chagar's insistence that we act against coercive practices. I am deeply concerned, however, that the current definition of conversion therapy found in Bill C-6 goes much further than the stated goal of criminalizing coercive behavior. In this bill, there is no requirement that the practice, treatment, or service in question be coercive or cause harm. The bill fails to define exactly what constitutes a practice, treatment, or service. Actions that are now lawful could be subject to the criminal code. In its current form, the legislation lacks protection in relation to the following: the fundamental right of parents as first educators and guardians to make decisions regarding the welfare of their children, specifically their freedom to instruct them in accord with their religious and ethical beliefs; the right and freedom of every Canadian to voluntarily seek support, to live in a manner consistent with their identity and beliefs, and in accord with their personal convictions; the right and freedom of the Church and other religious communities to support persons who choose to live their lives and sexuality in accord with moral teachings and the dictates of conscience; the right and freedom of the Church and other religious communities to share their religious and ethical beliefs regarding the human person and human sexuality. Now, some within the government have said that clearly this bill is not intended to criminalize some of the points that I've just mentioned. Be that as it may, no such protection is actually present in the text of the legislation, and it is the text that will become law. If I may cite an example, when the euthanasia law was passed in 2016, we were assured that language in the preamble would be sufficient to protect conscience rights for those not wishing to participate in the act of taking a patient's life. That has turned out not to be true. Any law concerning conversion therapy must strike a careful balance. On the one hand, the law must recognize that coercive and harmful practices have no place in our social order. On the other hand, the law must not criminalize the charter-protected beliefs of Canadian people. While these beliefs may not find popular acclaim and may even be offensive to some, the fact remains that many people freely choose to live their lives in accordance with traditional principles and beliefs. Tolerance and diversity are a two-way street. Educators, counselors, parents, and pastoral leaders should be allowed to express their views freely and without fear of punishment. This is certainly true when it comes to faith communities because in practice, in our society, they are now and always have been at the forefront in caring for the most vulnerable. I hope that this committee will seriously reflect on these concerns and amend Bill C6 to criminalize conversion therapy in a more careful and accurate manner. While we must address the suffering caused by any harmful coercive practices to ensure they are no longer present in our country, at the same time we must permit respectful dialogue and expression of diverse views in a way that supports deeply enshrined principles in the Canadian Charter of Rights and Freedoms. It is the coercive and harmful element that we must focus on and not be too broad in the definition. I thank you for the opportunity to share my comments with you this afternoon.
Thank you very much. We'll now move into our first round of questions, starting with Madame Finley for 6 minutes. Go ahead, Madame.
Thank you, Madam Chair, and thank you to all the witnesses who are appearing here today. We really appreciate your input. Dr. Dobson, thank you for your thoughts. As a medical professional, can you outline how this lack of clarity in the law might impact other medical professionals when trying to assist patients?
Well, currently in Ontario, of course, you can be disciplined by your college if you do anything other than affirmation therapy. So it's already restricted here in Ontario, unfortunately. But with the threat of jail time, I guess it'll be already further restricted. You see, because so many of the people with gender dysphoria have concomitant psychiatric diagnosis, and they need that to be treated. And they're being rushed onto the biomedical model of puberty blockers and cross-sex hormones because of the fear in therapists that they will be accused of, quote, conversion therapy. Well, I don't think anybody wants anybody to suffer with gender dysphoria. But it's very, very important then for anybody with anxiety, depression, all these other symptoms that are comorbid to be treated. And they shouldn't lose out on that just because of the fear of being labeled as conversion therapy.
Thank you. Cardinal Collins, thank you also for being here. The Minister of Justice has said that this bill will not infringe on good faith conversations. However, he also said in his testimony before this committee that there seems to be confusion around the scope of the bill. We've heard from a number of witnesses who are concerned by the disconnect between the language of the minister and what is contained in the bill. Would you support seeing an amendment that clarifies that the bill does not criminalize those good faith conversations?
Absolutely. I think that's really essential because as it stands, whatever the assurances are and the good intentions even around the bill, the fact is, as it stands, it does have this problem. If there was to be an amendment that said only coercive behavior or behavior causing harm, practices that cause harm are to be criminalized, well, that makes some sense. But, and that would be the kind of thing that I believe Rabbi Whitman is concerned with. But as it is right now, it doesn't have those protections. And so we might assume them, but they're not there. And I'm very concerned that we would have, for example, groups within my own community which seek to help and guide people in living a life of Christian chastity, in which everyone freely enters into it. There's no coercion, there's no harm, but these are behaviors which I think would come under the repressing non-heterosexual sexual behavior, believing that this is not the way that we're called to live in Christ. So that is where freely chosen practices are being penalized or criminalized. I think that's just not right. A simple amendment to say it's coercive behavior or practices that cause harm. Nobody wants someone to be forced, manipulated into any kind of therapy. And that should obviously be forbidden. And that, I think, is what Rabbi Whitman is concerned about. Absolutely.
Thank you.
That's only the thing.
Thank you. Mr. Santoro, about the broadness of the definition as it is now of conversion therapy in C6, do you believe, because of how the bill is written now, that it could be struck down?
Well, I think that if the situation arose, some of the particular circumstances that arose that you've heard from witnesses, detransitioning, etc., were to arise, you'd have to look at each case on its fact. And the fact of the matter is that if this law prevented some form of therapy or medical treatment that this person wanted, freely chose, that doctors and therapists are saying that they should have, that it wouldn't be harmful, if this law prevented that, which I think it very well may, then it could be very well struck down, either as violating the healthcare power or as overbroad.
Now, as a lawyer, you would know if it was struck down, that would mean that the government would then need to go back to the drawing board and amend the law. So by not amending the bill now to clarify what the bill impacts and what it does not, is it your opinion that Parliament would then be faced with having to come back and amend the bill down the road?
It's much better to amend it now. It's going to save a lot of trouble. It's going to save a lot of potential litigation, confusion amongst people. If you just put clear language in saying that conversion therapy is a coercive practice, that will solve a lot of the problems, as well as the other suggestion that I made about the medical treatment. Don't specify one form of medical treatment, just make it a generic medical treatment exception, as well as the other suggestion you just made, which says protecting conscientious speech and opinions.
Quickly, Mr. Santoro, is there adequate protection now, do you believe, for good faith conversations? Very quick answer, please.
No, because exploration of identity or development, I take it to be some kind of an expressive exception, but it's a very confusing term. I would suggest employing established terminology from other sections of the criminal code, such as the hate speech provision, which says that you can have conscientiously held opinions being expressed. There's mention of religious texts, etc. So just use established language from other sections. Don't try to invent novel terminology. The courts will have a hard time figuring out what that means.
Thank you.
Thank you very much, Madam Findlay. We'll now go on to Mr. Maloney for 6 minutes. Go ahead, sir.
Thank you, Madam Chair, and thank you to all of our witnesses for appearing today. This legislation results in a lot of charged conversations and extreme opinions, in my view. If you listen to some of our witnesses today, you would think this legislation mandates therapy, forcing people to go in a certain direction, when in fact the legislation does exactly the opposite. I think that's an absurd interpretation and frankly an outrageous statement, but those are just my views. This legislation's intent is to prevent exactly what has been explained to us, and Dr. Dobson, you referenced it earlier in your opening statement. You said, why is the government telling people what sexual goals they should have? This legislation does not say that anywhere. It does not do that, in my opinion. And I will respectfully disagree, but I'm going to direct my questions to Your Eminence, Cardinal Collins. Although I'm a practicing Catholic and went to Our Lady of Sorrows School and I'm still a parishioner there, and went to Michael Power High School, you and I have not had it's not been my honor to meet you before. I struggle. I tell you that only because being born and raised a Catholic, I understand the struggles some people face with this legislation and this issue. But nowhere in this bill, Your Eminence, does it say that anything that will in any way limit what I can say to you in a confessional, or that you can say to me in the confines of our relationship. And I that's why I have so much difficulty. I mean, the Catholic Church teaches that sexual acts outside of marriage are not allowed. That includes homosexual relationships and heterosexual relationships. To my knowledge, that is in a heterosexual relationship is legal. No priest that I'm aware of has ever been charged with a crime for espousing that view to his parishioner. And nowhere in this legislation is that going to change when it comes to people who are in non-heterosexual relationships. So, Your Eminence, I want you to help me understand where you're coming from, because I've read the brief submitted by the Conference of Catholic Bishops, and I don't agree with those conclusions.
Well, thank you, Mr. Maloney, and I think that is a very thorough brief, which can obviously say more than one can say in a short conversation. Conversion therapy is something that is to be banned. That's the thing that is the goal. I would say conversion therapy, if it is coercive and so on, but it's just conversion therapy. What is it? It's a practice, treatment, or service designed to change a person's sexual orientation or whatever, or to repress or to reduce non-heterosexual attraction or sexual behavior. Well, any practice that reduces, I would say, heterosexual or non-heterosexual sexual behavior is conversion therapy. That's what it says. Now, what is a practice we could have? Well, we have certain things. For example, we have groups within the church, which I highly support, of people who freely enter into them, people with experiencing same-sex attraction, who are indeed quite intending to reduce non-heterosexual sexual behavior. They want to live a life of chastity. That, according to this overbroad, overreaching definition, that's the equivalent. That's what conversion therapy involves. So it's any practice that seeks to change a person's sexual orientation and so on, and reduce non-heterosexual attraction or sexual behavior. That would involve a lot of spiritual groups that I've been involved with in terms of organizing them, a thing called Courage, and various other groups, which are precisely designed to help a person live a life of chastity, which involves discipline of one's sexual behavior.
But sorry to interrupt. I have limited amount of time, but discipline of one's sexual behavior is distinct from sexual orientation.
No, it says reduce non-heterosexual attraction or sexual behavior. That's what the bill says. It may not be what people think the bill means, but that's what it says. And unfortunately, what it says is what gets into the law and ends up being interpreted later.
Nowhere in this law, Your Eminence, does it say that you are going to be limited, or parents, as you have identified, are going to be restricted in advocating the teaching and beliefs of our church. And the source of the suggestion that it will somehow do that are from people who are opposed to this legislation.
Well, I am opposed.
I'm struggling between a Catholic and a lawyer here, and the lawyer in me tells me this legislation does not come anywhere close to doing the things that are being alleged.
Well, the Catholic in me tells me that the type of spiritual guidance and practices we have, I don't have time now, but I can talk to you later about them, which help people living a life of, in the case of people that experience the same-sex attraction, helping them to reduce non-heterosexual sexual behavior. Indeed, one could, if we were dealing with something with heterosexual behavior, that could be there as well. This is very problematic. A simple change dealing with, is it coercive behavior that we're trying to outlaw? That would solve the problem. But as it stands, it will interfere with a lot of things which I've mentioned and which the Canadian Bishops thing mentions at greater length.
Thank you. And that's all the time we have there. Now we'll go on.
I would like to talk to you further, Your Eminence, if that's it.
Be glad to do so. Just come and see me anytime.
Thank you. Monsieur Fortin, you have 6 minutes. Go ahead, sir.
Thank you, Madam Chair. I'd like to thank all the witnesses for appearing today. As I was mentioning earlier, what's unfortunate is that the more we hear people on C6, the more we realize that there is a lack of clarity. I think that all parliamentarians came to this in good faith. They want to ban practices that we can all agree are not honoring of the person. But I would agree with what Cardinal Collins said just now. It's the language that's going to be the legal support. And unfortunately, I believe that the text as it stands right now is confusing. But that being said, I also agree that good faith conversations should be allowed. But I do wonder what a good faith conversation would be and whether that good faith conversation from an individual's point of view could be in bad faith from a different point of view. What I'm saying is that our moral and religious beliefs will vary from one person to the next, from one religion to the next as well. And I was wondering, Cardinal Collins, how would you perceive the issue of, say somebody comes to see you and is questioning themselves. Say a young person who's maybe 13, 14 years old, who has gender identity questions. They tell you, well, maybe I'm bisexual. I'm experiencing attraction for young women and young men, and I think that's okay. What would your opinion be when that youth came to see you, Cardinal? Yes, thank you for your question. I would like to speak French on this very delicate and nuanced question, but unfortunately, I don't have all the range that I would like to give it in French, so I will be answering in English.
Suppose you have a young person who is struggling with they have gender dysphoria or whatever, and often they get people more and more influenced by the society around them. I would say they need to be listened to, spoken with, encouraged. And if there's somebody influencing them, saying if at the moment they're somewhat confused, some kids do get confused, and say go in the direction that Dr. Dobson was saying some people are asked to do, and she gave the example from England. I would say let's not do that. Let's just listen, be compassionate, understanding, and I would not encourage such a person to enter into practices of, for example, transitioning and things like that. That is happening though. If I were a parent or a counselor, a priest, and a person comes to me with these issues, I would advise them not to go in that direction. Now, I would be, giving them advice in my own way, which would be, I think, potentially getting in the way of this law. I think there's a greater danger of that in groups and things like that, which would seek to give counseling, especially in dealing with the issue of homosexuality. But I think we have to just listen and understand. And this law is too, like if I'm trying to convince someone not to go in a direction, that could be conversion therapy. It's not. I don't think coercive things should be banned, as the rabbi mentioned. But advice for people not to go in a certain direction, I don't think should be banned.
Merci. Cardinal Collins, je vais y aller encore avec vous.
Thank you. Just a follow-up question, Cardinal. In your opinion, do you think that all priests, rabbis, imams, whatever, religious leaders, do you feel that they would all intervene in that way, in this affirming way that was described by Dr. Dobson earlier? Do you think they would all listen without trying to influence? Or do you feel that other religious leaders, may they be Catholic or any other, do you feel that some religious leaders may feel that they should correct certain tendencies or youth sexual behaviors.
A friend of mine testified, a person I know very well, testified a while ago about some priests behaving in a rather strange manner, about exercising and exorcism and stuff. That I do not agree with. I think that can happen in any religion, including my own. I would not approve such an action. But there are, and I'm sure it might happen in Jewish, Muslim, I don't know, or Protestant groups. You always have individual priests, ministers, rabbis, imams. But I think the most important thing is to be able to have a person counsel and be able to do that, and including to counsel, which I would do, if a person, I would be counseling against homosexual sexual behavior. I don't believe that is the right direction. I would not force anyone. I don't coerce anyone, but I just don't think that's the way to go. And we have ways of helping people deal with this issue in their life freely entered into, which are, I think, very fruitful and good. They're not coercive, but I think they would be captured under this definition. And I don't think that's right. Simple word, coercive, solves the problem.
And that is all the time we have, Monsieur Fortin, for 6 minutes. Now we'll go to Mr. Garrison, who will be our last questioner for today. Go ahead, Mr. Garrison.
Thank you very much, Madam Chair, and I want to thank all the witnesses for appearing today and say that it's not very often we have witnesses of the stature of Cardinal Collins and Rabbi Whitman before the committee. And given that Cardinal Collins has had a fair degree of time, I want to focus my questions with Rabbi Whitman. I think you're in a kind of unique position as a witness here because you come to us as both a legal scholar and a biblical scholar. And so my question to you first off would be, do you see anything in this bill generally or specifically that you feel would limit you in the carrying out of your professional duties and responsibilities or spiritual duties and responsibilities as a rabbi?
First of all, thank you for placing me in such august company as the other two speakers, and I'm honored. My understanding of conversion therapy is a type of activity that is coercive, so I would certainly support clarifying that point. However, it seems to me from my reading of the bill that it already allows for free expression of religious principles and good faith conversations. I don't see that that is contraindicated by this bill.
And on the question of adults being subjected to conversion therapy, the bill presumes that there is such a thing as a consenting adult to conversion therapy. Would you have any comment on whether people can actually consent to a process which has been found by professionals to be fraudulent and harmful?
I think that's a very hard line to draw. Dr. Dobson made reference to the fact that a lot of individuals may have multiple issues, emotional issues at the same time. And so, yes, if it was actually free consent and full consent, a person, I think, has the right to do that. But a person could very easily be in a situation where they feel compelled, they feel pressured, and it would be very hard to judge free and full consent.
And in your experience as a rabbi, how often do you think that conversion therapy is taking place either within the Jewish community or other faith communities in Canada?
That's hard for me to answer. I have not personally encountered it. My guess would be that it exists within the fringes of the Jewish community in some of the larger areas. But I know that within the mainstream Jewish community of all denominations, Orthodox, Conservative, and Reform, that it is pretty much discredited and not practiced. So if it exists now, it exists at the edges.
Thank you. The human rights legislation in Canada has affirmed protection for discrimination against on the basis of gender identity or gender expression. And we've heard testimony from witnesses suggesting this bill should depart from that and only protect sexual orientation from conversion therapy. Would you have an opinion on the breadth of the bill? Should it include gender identity and gender expression?
I think if we're talking about an activity that is coercive and that is harmful, it should apply in all situations.
Great. Thank you, Madam Chair. I know we're out of time for our session, so I'll conclude my questions there.
Thank you very much, Mr. Garrison. And I'd like to take the opportunity now on behalf of our committee to thank this wonderful group of witnesses and panelists. Thank you for your input. And I would like to remind members that the deadline for amendments is December 9th by 9 a.m. If you haven't already submitted amendments, please make sure that you do so before that deadline. And now I'll pass it over to Mr. Clerk for some remarks.
Merci beaucoup, Madame la Présidente. Je voulais juste informer le comité.
Thank you very much, Madam Chair. The committee has received nearly 300 briefs on Bill C6. That's huge, and about 260 are in translation right now. So I would like to thank the administrative team at the committee's directorate looking after these briefs, especially Natasha Filoso, who worked all weekend. I would also like to thank the Translation Bureau team, who are very busy right now, are working very hard to translate all of these briefs. Most of them should be ready by the time we do clause-by-clause consideration, but about 30 may come in after that. So once again, thank you very much to everyone for this huge effort.
Much for that, seriously. Really wonderful. Thank you for all of your hard work and friend, for keeping us going. We really appreciate that. With that, the meeting now stands adjourned.